Okay, so in this video we're going to look at the process of applying for planning permission and what's involved in it. So obviously this is governed by the legislation we discussed in the first lecture on the Unit 4. So it's governed by the Planning and Development Act 2000, and the consolidated versions are available on the Moodle page and here. And also the regulations, which are really where it's at in terms of the detailed nuts and bolts that we're going to be looking at in this lecture. So, first of all, before you apply for planning permission, you have to establish, is planning permission required? Planning permission is required anytime development is carried out. Development means any works in or on or over or under land, or the making of any material change in use of any structures of land. So, works are defined as any construction, excavation, demolition, the usual stuff that you'd imagine works would be. Alteration, repair, renewal, application, removal of plaster, paint, wallpaper, tiles, all of that kind of stuff. And it's important to remember that this type of works you'll find in the exemptions in the Planning and Development Regulations. So most people don't have to apply for planning permission to paint their house or to plaster their house or wallpaper their house. But some people do. So if you have a listed building that's listed on the Historic Sites Register as a building of historical interest, and the whole building, not just the facade, is listed, you might have to apply for planning permission if you want to plaster, paint or wallpaper or tile your house internally, or change the structure or layout internally. So you also have then alteration, which is plastering, painting, removal of plaster, stucco, the replacement of door, window or roof that materially alters the external appearance of the structure so as to render it inconsistent with the character of the neighbouring structures. So alteration is kind of a slippery design of a definition. It's an idea of changing the character of the building in a fundamental way. Use then is the idea of changing how the land is used. A lot of people forget about this one. And this means that if you operate a business on your property and you change the nature of the business that you're operating on your property, then that's a change of use. So if you use your land for agriculture and then you decide to change it to be used as a garage where mechanics operate, you put up a shed. Obviously the shed might require planning permission if it's a permanent structure, but also the change of use to running a business on it from agriculture is something that in itself requires planning permission. And agriculture is the baseline use, so you don't need planning permission for agricultural use because that's the default use. But every other use you require planning permission for. So permission is only required if there are works on the site or a material change in use. And if you're not sure, you can make an application under Section 5 to the local authority to determine whether it's exempted development or not. And they're quite common. You'll see those listed on your local authority website. So the local authority cannot permit developments which are a material contravention of their own development plans. You remember those development plans, they're under the regional spatial strategies, which are under the national spatial strategies, and they are a 6-year plan for the development of the county council's functional area. And if a development, just say the land has been zoned in the development plan industrial, they can't grant a residential permission there. That would be a material contravention of the plan, so they can't break their own plan. But there is a procedure for contravening the development plan, but it has to be followed carefully to the letter and involves an act invoked by the county manager, advertisements in the local paper, 75% council majority resolution. So it's a complex process that is difficult to achieve. So the role of the council then, so the council grants or refuses planning permission, and you apply to the county council as the planning authority, except for strategic infrastructure or strategic housing development. If the site covers 2 local authority areas, you apply to both, but one of them will take the lead. So they'll decide between them who's the lead authority, and you'll deal primarily with that one authority. You can apply for full planning permission for 5 years, or outline permission, which lasts for 3 years, which is general, permission to build a particular type. So it could be permission to build a residential one-off housing, but it won't set out the specifics of the type of house, whereas full planning permission is very specific, down to the type of windows and the shape of the house and all that kind of thing. So you don't need to be the owner of the land to apply for planning permission, but you do need to have the permission of the owner of the land. But you can apply for planning permission in relation to land which you don't own. You can enter into discussions with the council known as pre-planning consultations, and the county council advises on what might be likely to be acceptable. But they're not bound by any representations made in pre-planning. So legitimate expectation doesn't apply that it's a type of requirement on public bodies to act in accordance with their promises. But that doesn't apply here in pre-planning. They're not bound by it. So they could tell you one thing in pre-planning and then refuse your application even though it complied with the pre-planning discussions. So what are the notice requirements? So planning applications in Ireland are subject to participation by absolutely anybody who wants to participate in them. So the world and its mother literally can put in objections, submissions, observations on your planning application for your residential house that you're trying to build, or your factory or your business or whatever. And you must notify the world that you are doing a development, you're doing works or use change with land. And you do this by 2 ways. So you put up 2 weeks prior to the application a newspaper notice in local newspapers and a site notice for 2 weeks prior to lodging the application. And the site notice must be visible on the road outside the site and in the form contained in the Planning and Development Act or Planning and Development Regulations 2001 as amended. And it must be kept in place for 5 weeks. If someone steals it, you must put it back. It must be there for the full 5 weeks. If it turns out that it wasn't there for the full 5 weeks, so if someone can prove that, that will undermine any later planning permission granted. So the notices are very important. You submit copies of the site notice and the newspaper notice with your planning application, and you give the date of the newspaper notice, a photocopy of the newspaper, to show it was in for 2 weeks before the application was lodged, and they're essential proofs for your application. They go in the planning file. You can look them up. You can look up any planning application on your local authority website and see the newspaper notice on the file scanned in. So notices ensure members of the public can participate in the planning process, put in their observations and submissions and objections to your planning application. And the planning authority randomly inspects the site to make sure the signs are up for the required period of time. The application must contain the relevant page of the newspaper showing the newspaper notice, a copy of the site notice, consent of the owner if you're not the owner, the suitability details for the site for wastewater treatment if that's relevant, 6 copies of site location maps, a schedule of documents, plans and drawings, and a site plan or layout. Also other plans, sections and elevations that might be helpful in giving the County Council an idea of what you're doing. So your architect's drawings usually. And if the application's for housing development, either for an exemption certificate or a copy of the application for an exemption certificate as to how the provisions of the housing strategy are to be complied with must be submitted as well. And 10 copies of the environmental impact assessment. So we'll be looking at that in a different set of lectures in topic 3. So we're applying for works to a protected structure. So they're sites which are on the Historic Sites Register. Or the exterior of the structure is in an architectural conservation area, then you have to show exactly how the development will affect the protected structure. You have to include your fee, and then if the application's for change of use, only a statement of the existing use and particulars of how that's going to change. So the application forms are in Schedule 3 of the Planning and Development Regulations 2001 as amended, and Article 22 of the Planning and Development Regulations sets out the information which must be in the application form. So you can look those up on the links I gave you of the regulations. When the Planning Authority receives your application, first they consider if it needs any further information. They'll stamp each document with date of receipt, and that starts the clock running for the time periods in the Act. If any of the site notice requirements are not complied with, their application is just sent back and returned together with the fee. Valid applications must be decided on within 8 weeks of receipt, but no earlier than 5 weeks, because that is the window for observation by the public. So you can't decide before you receive all the observations and consider them. Any person can make an objection or submission, so there's full public participation in the planning process in Ireland. It's actually, you had that very early on from the 1960s, and we were very advanced compared to some other countries in Europe with that. So the decision must be made within 4 weeks of receipt of further information, or 5 weeks if an EIS is involved. And there are time limits which were amended in 2010, giving the Planning Authority a further grace period of 12 weeks after the expiration of the first period of 8 weeks within which to make a decision. But resorting to that has consequences, and the Planning Authority might have to pay a penalty to the applicant equal to the lesser amount of 3 times the prescribed fee paid by the applicant to the Planning Authority in respect to their application, or 10 grand, whichever is the lesser. So there is consequences to encourage the planning authority not to avail of the further grace period of 12 weeks. There's the issue of default permission. So if the application isn't decided within the required time frame of 8 weeks or 8 weeks plus 12, whichever is applicable, then the application is deemed to have been granted. But it's not automatic. You have to actually go to court to ask the court to give you an order saying the application has been granted by way of judicial review, which we'll be looking at in later lectures. And the default permission will not be granted by the court if there are any technical flaws in your application, or if the application is one that required environmental impact assessment, because they cannot grant, the court will not grant planning permission for a development that hasn't been assessed for environmental impacts if it falls into the category of developments which must be assessed. We'll find out what they are when we do environmental impact assessment in another topic of the course. So the 2010 Act also amends Section 34 to provide default permissions are not available in those cases of requiring environmental impact assessment, as I said. So who makes the decision? The county manager is the planning executive, and they usually delegate that to people in the planning department of the county councils, the planning officers in the department who are qualified planners. So the manager signs the order granting the permission, or refusing permission, but it's made by people, so it's made on the advice of the planning department. The county manager can overrule the planning department under Section 34, where he authorises a material contravention of the development plan, using that process we looked at earlier on, or where an elected official uses Section 140 of the Local Government Act 2001 to direct a manager to authorise planning permission for a particular development after a council resolution of 75% is passed. So the elected council officials can overrule the county manager in exceptional cases. So what did the planners consider? They consider proper planning and sustainable development of the area, amenity, common good, public health and safety, prematurity. So is there sufficient infrastructure? If you want to put in a 500 house estate, is there sufficient sewerage and road and water infrastructure in the area to carry that? Previous planning history of the lands and the applicant. So if you've broken planning conditions in the past, you could be refused. Matters prescribed by the Section 34 of the Planning and Development Act 2000. So provisions of the development plan, special amenity area orders, European site or other prescribed areas. So that's habitats of protected species, effectively. Relevant government policy. So that could be the National Climate Mitigation Plan, or the long-term strategy for climate change, or the National Spatial Strategy, any of those policies we talked about in the previous lecture. The types of conditions that can be granted, and then other relevant provisions of any act or legislation, local area plan, integrated area plans. They also considered the submissions received by the public, and also submissions by the local authorities, or regulatory authorities like the EPA, and third parties and prescribed bodies. So An Taisce are a prescribed body. They're a charity who have a right to object to any planning permission in the country, because that's been enshrined in legislation since the 1960s. What they cannot consider are irrelevant considerations, so compensation, if they would have to pay compensation for refusing the permission, and personal circumstance of the applicant. So that's not relevant if the person will lose their business over refusal of the permission. Permission can be granted with or without conditions, so they can just grant permission for the development as is, or they can say the development will be granted permission, but we're going to put some conditions on it, like you must plant trees around it to make it look nicer, or build a wall around it to mark the boundary, or something that wasn't in the application. And there's guidance on the conditions. So some of the examples of conditions that can be given are conditions requiring the carrying out of works, measures to prevent or reduce emissions, noise or vibration. So trees are often used to screen noise from other, developments. Requiring the provision of open spaces, so that's a common one in housing estate developments. Requiring the planting of plants, landscaping, that's also common in housing estate developments. The planning authority must give reasons or considerations for their decision. So that's so if we're not happy with the decision, we can challenge it. So if they've given reasons and those reasons are ultra vires, they're outside their powers, they're things they shouldn't have taken into account, then we can challenge that by way of judicial review, which is looked at in the later topics in this section of the course. So the reasons must be sufficient to give the applicant ammunition to challenge the decision before the courts. Permission lasts 5 years. On expiry, if there's no development within that time, it ceases. It can be extended if it's applied for before it expires, and substantial works have been carried out during the lifetime of the permission. So you must get